What is involved in co-ownership? When we talk about co-ownership, obviously we mean the way that more than one person owns a piece of property. So co-ownership is a form of ownership in which two or more persons have undivided interests in the same property. So undivided doesn't mean unequal, but undivided means that person can sell or do something with their own interest, pass it on to relatives or things like that. Joint tenancy. It's a form of co-ownership where the entire estate passes to the survivor on the death of the other joint tenant. So the rights of joint tenants. Each co-owner has equal right to possession of the entire property, and then the law considers occupancy by one as occupancy by all. So a joint tenancy, everybody has rights to use it, but when somebody dies, it passes to the other joint tenant. You can have 2, 3, 4, but if one person dies and 3 people own it, the other 2 become 50% owners. That would be how joint tenancy would work. Severance of joint tenancy ends when any of the 4 required unities terminates. So the unity of possession, of interest, of time, of title. Obviously, if they sell the piece of property, that's the possession. Interest, they sold their interest as well. Time, over time things can happen in unity of title, passing title to somebody else. Would be how any one of the 4 happens and the joint tenancy is dissolved. Tenancy in common is a form of concurrent ownership in which each owner possesses an undivided right to the entire parcel of land, with each owner's rights similar to those possessed by a sole owner. So the rights of the tenant in common. Each tenant in common has undivided right to possession of the entire parcel, and no tenant in common entitled to exclusive use of any part of the land. But tenants in common, obviously, yes, they can sell their interests. It's not worth as much as an entire parcel, but they can sell their interest in it without having to sell the entire piece of land. You don't see that a whole lot in residential real estate, but you do see it in commercial real estate, where the tenants in common sell off their own small parcels. Again, they're not selling the building, they're just selling their interest. Partition, an action by which a co-owner obtains a division of property terminating any interest of other co-owners in the divided portion. So a partition would be a legal type action. They're going to go to a court and file for partition. Tenancy by the entirety. This is the only one that's husband and spouse, and you need to understand the entirety. This is one that you want to memorize for all your real estate tests, is the co-ownership of the property by husband and wife that is non-severable without the consent of both. In today's laws, it's not necessarily husband and wife, it's by 2 that are married. On the death of either, the survivor remains as the sole owner, but they have to own it as tenancy by the entirety, and therefore they are both named in the deed or the ownership interest. The termination happens that can be, they're not terminated without the other's consent. And the tenancy by the entireties are terminated by divorce. And that's where the partition happens. They go to court, and the partition happens in the divorce decree where this tenancy gets terminated. Tenancy in partnership is a form of co-ownership in which each partner owns partnership property together with the other partners. Each partner's share is treated as personal property, and partnership property of a deceased partner passes to surviving partners. So this is kind of like the joint tenancy, it passes to surviving partners. Community property is a form of co-ownership between husband and wife in which each has 1/2 interest in property acquired through the labor of either during the marriage. So when famous people get divorced, they try to go to a state that may or may not have community property, depending on how they want to get rights to that other person's property. If it's a community property state and somebody brought a lot of wealth into the marriage, they wouldn't be wanting to divorce. The person that has the wealth might divorce in community property state, but somebody else might say, no, we want to divorce somewhere else so that I can recognize other things that you brought into the marriage as part of my property. Is that equitable or fair? Not necessarily, But this is also a part of how people determine where they're going to be divorced. It's not necessarily where they reside, it's where they want to have the court hearing. And if wealthy people own multiple parcels of real estate, that might dictate where they take their divorce case. Separate property. Property owned by a husband and wife prior to marriage, and property acquired during the marriage by gift or inheritance. A real estate syndicate is a group of investors who combine funds and managerial resources to develop, manage, or purchase real estate for a profit or as a tax shelter. A syndicate is not the form of the ownership, so investors must organize in some legal form, such as a corporation, S-corp, partnership, limited liability company, or joint venture or trust. Once the syndicate comes together, they pool their money together, and then they buy their piece of real estate. Then they are forming a corporation, S-corp, or partnership, or LLC, to be able to actually hold title to that piece of real estate. A syndicate happens when we have wealthy investors that say, hey, wait a minute, I want to go buy this piece of property. I think I can make it profitable, and I need a group of funds pulled together. I'm not going to go get a mortgage necessarily, but I want to get all my friends together and all these people I know and make some money for them, and I'll form a syndicate to buy this piece of real estate, and everybody gets paid out based on how this real estate performs when we sell or they sell, things like that. So the syndicate, again, it's not the actual ownership entity, but it's a group of people coming together to be able to buy an investment. A syndicate's, again, corporation. They're shareholders. They enjoy limited liability. The reason they want to be shareholders in an LLC is they're not the managing partner. The limited liability is only their investment. They're only liable to their investment. They could lose their entire investment, but nothing will come back to their other investments. It's just the amount of investment they put in that syndication. Corporation enjoys perpetual life. Its continuity is not interrupted because of changes in stock ownership, so people can buy and sell into it. It never fades away. There is double taxation in corporation. You're paying taxes based on the corporate earnings and then on the shareholder earnings. An S-corp allows syndicates to pass income through without being taxed at the corporate level. So the S-corp doesn't pay taxes at the corporate level. The shareholders get taxed at their level. So again, there's a lot of tax law things involved in how you organize your ownership, corporation, partnership, and this is something that when you become an investor, you want to deal with an attorney and a tax accountant to seek the best way to form your ownership interests. And a partnership is an association of two or more persons to organize a business venture and divide the profits. We have limited partnerships, and then we have limited partners' actions, and the liability is limited because they are indeed a limited partner. But then there's also the general partner, the person who's actually responsible for managing, making the daily choices, and they have a much larger liability when it comes to anything that happens with that partnership and how they have to answer to courts of law. Joint ventures. It's a business entity in which two or more persons have agreed to carry out a single undertaking for a profit. They're similar partnerships, however, the joint venture is usually created to carry out a single transaction, again, just to make the acquisition of a particular piece of real estate. Each participant has limited power to bind the others, so they're not going to be able to go out and sign contracts or do anything like that. They can speak on behalf of the partnership, but they can't bind it to anything. And what they're speaking is really only their opinion. It's not binding law. Each participant has limited power to bind the others. Each owes a duty of loyalty and good faith to the other co-venturers, and the death of a joint venture does not automatically dissolve a joint venture unless it's only two. Usually what will happen is the joint venture goes on, and the heirs of that the venture partner that dies, the heirs would benefit from that. Limited liability corps, a business entity that resembles and is usually taxed like a partnership, but offers the advantages of limited liability for the owners like a corporation. Investors in the LLC are called owners, and managers are called members. The LLC is the type of thing we tell investors to do to organize their ownership interest through an LLC so that their private other investments aren't liable for something that might happen. A catastrophe happens at a piece of property, and if they don't own it as an LLC, they own it along with all their other investments, the courts could come back to them as a whole total to try to seek retribution. Whereas an LLC is simply that. It's limited to the walls of that environment. Very often buildings are owned as LLCs, and if something happens to that building, anything liability-wise is limited to that building and that building's accounts and through the bank. But if you can, the people that are seeking retribution can't go anywhere else to get funds or get paid. It's just that building. They can force the liquidation or the sale of that piece of property, but again, they're limited to just that piece of property to get their monies. We have trust syndicates. It's a legal relationship in which a grantor transfers legal title to a property to a trust, which holds the property for the benefit of third parties or beneficiaries. The trustee is given title of the property is managed for the benefit of others. The trustee has a fiduciary duty, responsibility of the trustee for the utmost good faith and undivided loyalty to the beneficiary. Throughout real estate, you will hear this fiduciary duty. As a realtor, you have a fiduciary duty to your clients and customers. It's a responsibility of them to put forth this good faith, undivided loyalty to the beneficiary, hold that person in the highest regard, and do everything better than you would for yourself for that person you have this fiduciary relationship or responsibility for. So a trust, again, through the syndicate process, they put it into a trust and run it that way. And then you might hear about real estate investment trusts. That might be something where you buy in as a stockholder, shareholder, but the real estate investment trust is organized to run the real estate investments of that trust, and you benefit by being a shareholder in a real estate investment trust.